Hi, this is Scott Brady, owner of Progressive Property Management. We're going to talk about today about some rental laws that are currently in effect and also some trends that we're going to see here in the next few years that are really important to you as an investment property owner. So first, let's talk about the new laws that are impacting real estate. First is AB 1482, which was signed into law in October. It's effective January 1st, and it's really called the Tenant Protection Act of 2019. This is big. This is the first time we have statewide rent caps in effect along with just cause eviction. So let's dig into that. First of all, which properties are affected by this law? It's any multi-unit building, so there'd be 2 units or more. It doesn't make a difference how old it is, it's just 2 units or more. So if you have a single family home or a condo, you're not impacted by this law. But even if you're not impacted by the law, you need to disclose to the tenants that they don't get the privileges of that law. What does that mean? Right now, the California Association of Realtors is preparing a disclosure form that needs to be sent to every tenant in the state of California before August 1st, 2020. We're going to deliver that form early by about January. And that form is simply going to tell the tenant whether they're protected by this act or they're excluded from this act. Simple as that. So if you're excluded from the act, you've got to let them know, because if they were to down the road you want to remove that tenant, and you didn't disclose to them, they may be able to say, well, gee, you didn't tell me I didn't belong, so I assume I did belong. And of course, you have to pay them the relocation fee. And that's the key here. If you're under this law, it's 2 units or more, you don't live in one of the units, then if you want to give your tenant notice, that is, you wanted to have possession of the property back, then you're going to have to pay them 1 month's rent. And that can be they can either forego the last month's rent, or you have to write them a check once they vacate the property. So that's important, because to date, if you wanted possession back, we just give your tenant a 60-day notice to vacate. You get the property back, you can find another tenant. That's no longer true if you're impacted by this law. Now you have to pay for a tenant to leave. Now, if a tenant is not behaving, a tenant's not abiding by the terms of the contract, and that's just cause. You have cause to then evict them and not have to pay them a relocation fee. But if they are abiding by the terms of the contract, they are paying as agreed, then now you're going to have to pay them that relocation fee. We have a blog on our website, so feel free to go in there and dig a little deeper in some of the nuances of this law. But it's a game changer. It's the first statewide rent cap, and that rent cap, so that's part of it. So the first is just cause eviction, paying them a relocation fee. The rent cap is now 5% over the CPI, the Consumer Price Index. That's a maximum you can increase the rent for these properties that are impacted. Once again, if it's 2 units or more, or it's a single family home owned by a real estate investment trust, which is 99.99% if you're not involved in that. But now, if you want to increase the rent, right now you can increase your rent by 30% with a 60-day notice. Now you're limited to 5% of a CPI. So this year that'd be roughly 7%, but Consumer Price Index changes annually. And it's probably at a low right now. So now you can only increase the rent in the next 12 months in California, starting, even though the law is effective January 1st, it rolls back to March of 2019. So the most you increase the rent in a 12-month period is 7.2%. You can increase it 7.2% or 3.6, and the 3.6, the bottom line is no more than currently 5% of a CPI in any 12-month period. The second law that passed, and it's already law now, it's Senate Bill 329. It got a lot less press, but it's really important. And that is the fact that you can no longer say no to Section 8 housing. If you're not familiar with Section 8 housing, that's a federal program that for people that can't afford rent, they apply to this program. They prove to the government, they show them their income, that they're not able to pay for a rental, and the government gives them the rest of that money for the rent. That's called Section 8 housing or voucher housing. And right now, well, before this law became law, if somebody called us and our owner didn't want to participate in that program, we say, no, we're not accepting Section 8. Now you can no longer say that. They're a protected class. So they still have to meet your criteria. So for Section 8 housing, typically the government wants to dictate the rent, and typically that can be below market, not always, but it can be. Usually the Section 8 participant doesn't have 2 months rent as security deposit, may only have 1 month rent. So you can still have your standards, that could be credit, that could be 2 months security deposit, if that's what it is, of course, but it can't be income. You can't say, no, you're not participating. You're saying, sure, if you qualify for our rent and what our standards are. If you were to say that now, that's a fair housing violation, and that's an immediate fine of over $20,000. So be aware that you can no longer say no to Section 8. You can say no to people who aren't qualified for your property, but not just because they're on Section 8 is not excluder. A couple other laws are coming, and I'm going to touch on briefly. There's a trend, definitely a trend. If you want to look at what the state of Washington's doing, also the state of Minnesota, the trend is that you don't get to pick the best qualified tenant. You've got to pick the first qualified tenant. So if your standards are a 650 credit score and 3 times the income for compared to the rent, the asking rent, and no evictions the last 12 months, whoever meets those qualifications first gets the property. That's now law in the state of Washington. I think that could be something we're looking at. The other law that will be on the ballot coming up this year is vacancy decontrol. What does that mean? So right now, if a tenant leaves your property and it's subject to these rent caps and this just cause eviction, you're allowed to bring the rent to market. So let's say you're way below market for whatever reason, you're at $1,500, but market rent is $2,000. The tenant leaves, or you pay them to leave. You give them notice and you pay them that relocation fee of 1 month's rent, but then you can bring the rent right up to $2,000. It actually makes sense in some cases to remove those tenants. There's a ballot measure coming that you won't be able to do that anymore. The most you could increase the rent is 15% from the last basis. So in that $1,500 case, you can only increase it 15% over the course of a year. So that's roughly only $200. So now your rent's only $1,700, not $2,000. These are the first, I believe, in many laws coming down the pike. And it's going to be more and more difficult, in my opinion, to self-manage. If you are going to self-manage, you need to be very aware of these new laws and the laws that are coming down the road, because it impacts your ability, what you can do with your tenant, or you may have to pay a real financial price. And if you have questions about what we do and our services, please call us. We're at 714-528-3100, and I thank you for your time.